Everybody know you, Mr. Ndukwe. How are you doing?
I'm fine, George. How are you?
Good. Hold on, I'm still letting people in.
What's going on, Joey?
I don't think he heard you. Mr. Ndukwe?
Yes.
Okay.
Come by next time you're around in the building. Come say hi.
Jesus Christ.
Yeah, you should come by and say hi to us.
I will.
All right, all right. So in keeping with compliance of the Texas Open Courts Act, we are streaming live on YouTube. And the courtroom is also open as well.
Okay.
Okay, Mr. Ndukwe, I see you're here, your client is here. You ready to proceed?
Yes, Your Honor.
Okay, and Mr. Ramirez? Okay,
Yes, ma'am.
okay. We're just waiting on your, oh, is your client down there at the bottom, Mr. Smith?
No.
Oh, no, that's a different case. Okay, well, as soon as your client get here, we'll go and take your case up next.
Thank you, Your Honor.
You're welcome. All right. You ready?
I'm ready.
Okay, we are on the record in cause number DF 2217751. Counsel, would you please announce for the record?
Vincent Ndukwe, representing the petitioner, Terry Nicole Chenal.
Okay, Ms. Chenault, would you please raise your right hand? Do you
Yes.
swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You may put your hand down.
Okay.
Mr. Ndukwe, you may proceed.
Miss Chenal, tell the judge your name.
Terry Nicole Shamont.
You are presently, strike it. You have a child by name Sky Maria Harper, is that correct?
Yes.
That child was born on February 23rd, 2021, is that correct?
Yes, sir.
Who is the father of that child?
Beyonce Deshaun Harper.
Okay. And then today, you're asking the court to adjudicate Mr. Deontay Deshaun Harper as the biological father of the child.
Yes.
And making as well adjudication, making the legal father of the child.
Yes.
And establish a parent-child relationship between the father and the child. Is that correct?
Yes.
You and Mr. Deontay Harper used to live together. Is that correct?
Correct.
But you guys are no longer together at this time.
Right.
Okay. And is it because that the man had been violent towards you?
Yes.
Can you tell the judge a little bit about the history of violence he have perpetrated towards you and the child?
Maybe 3 days after discussing going our separate ways, I came in from
You gotta
work.
speak loud so that she can hear you very
I
clearly.
work night shift, so I came in maybe about 7 a.m. to take a shower. He came in pretty much harassing me. My mom had already told me to ignore him, so I did. I guess that kind of agitated him. So from the shower started the fight. He choked me. I had pulled a knife on him. I ended up being outside naked. The fight continued for maybe 30 minutes. And then by the time I picked up one of my phones to call my family, he had came out of nowhere and punched me 3 times. So I kind of just woke up kind of dazed. And from there, he had got his oldest child is a male. He was 4 years old at the time. He grabbed his son and he left. I called the police. The police showed up. We found the police report. He ended up calling me like 3 times while the cops were there.
Okay, is there another incident of domestic violence? I don't want you to spend the whole day telling the story. So what other things has he done to you that you believe constituted violence towards you?
There was another incident with my oldest child were involved. We were on the play site, and me and his 4-year-old son, my 1-year-old at the time, and my was 7.
Ms. Chenault, we can't hear you.
I told you gotta speak up.
Mr. Ndukwe, is it possible that y'all could switch?
Let's do that.
Thank you.
Can you hear me?
Yes.
Okay, so there was an incident where we were play fighting. Then my daughter jumped in. and I wasn't even turned their direction. I was playing with my baby girl and his son, and she just ended up screaming. And I asked him what happened, and he acknowledged that she put her nails in his skin. And we both are aware that my daughter has no nails because she bite her nails. So from that incident, another fight broke out. He ended up putting a pillow over my head. My daughter kept trying to jump in the fight to stop him. I kept having to push her away. That fight went on for maybe 30 minutes as well.
Okay, without telling the whole your whole life history. So they're having other incidents of domestic violence. If we spend an hour here, we take the time of the court. Is that correct?
Yes,
Okay. So you are asking the court today and to make a specific finding that there have been a domestic violence, child neglect, abuse 2 years before this petition was filed or during the pendency of this case. Is that correct?
during the case has been harassment.
Listen to the question. So you have already told the judge the violence involved, okay? So you are asking the court to make a specific finding that have been a domestic violence either 2 years before this divorce was filed or while the case is pending. Is that correct? Either or.
Either or, it was last year, so
Yeah, that's within 2 years. Is that correct?
correct.
Okay.
Correct.
And as a result of that domestic violence and abuse, you want the court to appoint you sole managing conservator. Is that correct?
Correct.
And with the exclusive right that was associated to sole managing conservator. Is that correct?
Yes.
And you don't want the judge to put any kind of geographic restriction on your rights to determine the primary residence of the child. Is that correct?
Correct.
Because he will be still chasing you around.
Correct.
And you're asking the court to make a finding that you don't want your address to be disclosed.
Correct.
And he know if you want to see the child, he know how to see the child. He know where your family is.
Correct.
And you want the judge to limit his visitation, and you want it to be supervised.
Correct.
By a competent adult actually chosen.
Correct.
And the time of visitation should be arranged between you and him. Is that correct?
Yes.
And then you want the judge to order him to pay child support beginning on March 1st. We're supposed to do this prove before. So you want the child support to begin on March 1st this year. Is that correct?
Correct.
And you want Mr. Hopper to provide the health insurance for your child. Is that correct?
Correct.
You believe the request you are on page 14 of your final order, you are asking the court to restrain Mr. Hopper from using any kind of corporal punishment on your child.
Correct.
Because he has been violent towards you.
Correct.
You don't want him to be violent towards your child, even when he was given an opportunity to visit. Is that correct?
Correct.
And you believe that the request you are seeking, the relief you are seeking today, is in the best interest of your child.
Yes.
And regarding the relief you are seeking that you don't want to disclose your address, you believe is in your best interest and the best interest of the public.
Yes, I do.
And you are asking the court to approve the order that you have submitted to the court.
Yes.
Georgia, I filed 3 orders. The last one is the one we're going by.
Okay. I believe that's the order that I have in front of me, Mr. Ndukwe. I do have, I'm sorry, are you finished with your client's testimony?
Yes, Your Honor.
Okay, I do have a question. I need to hear testimony about how she came to the amount of child support that she's asking the court to award.
Okay. Mrs. Chanel, when you are living with Mr. Hopper, how much was he bringing home at that time?
At the time, he was making about 18 an hour.
Okay, so that's how you calculated the child support. Is that correct?
Correct.
You don't know if he's making more or less at this time.
Correct.
But that's what you know he was making at the time the petition was filed.
Correct.
And you want the judge to, you believe he may have even getting a promotion because he has been in that job for a long time.
Well, not for a long time. He discussed that they wanted him to start driving trucks.
Driving truck.
That would be a promotion.
So that would be a promotion.
Correct.
So, but you want the judge to issue child support based on the amount we know. Is that correct?
Correct.
How's the witness, Your Honor?
Thank you. Okay, Mr. Ndukwe, I made a slight modification to your, let me make sure I'm looking at the right decree. I see not decree, the order. I see an amended final order in the SAPSER filed on February 17th, and then I see the default order filed February the 20th. Is the 20th the one that's the most recent? That's the one you're saying you're trying to file with the court?
Judge, can I email it to Joe?
Because I think I have, I mean, I have both.
If it's the last one, I thought it was accepted. I don't know. I look in the system. I don't know what I was withholding. I was accepted on 24th or the
Okay. Okay, so then I signed the right one.
Okay.
Yes, I signed the right one, and I made a slight edit to the income withholding order in terms of when you wanted the date to start. All right, so the court, after hearing testimony, the court will grant the order as it is written. The court also finds that Deontay Harper, Deontay Harper was served with notice of the petition on December the 27th, 2022. That notice has been on file with the court since January 3rd, 2023. He did not file an answer and did not sign a waiver. He is made wholly in default. The court has signed the order, Mr. Ndukwe, and you and your client will receive a copy of it today.
Thank you, Judge.
Welcome.
Are we excused?
Yes, thank you.
Thank
for being
you.
here.
Thank you.
You're welcome.
Have my seat. See you
Okay,
later, Miss Joey.
Bye, Vincent. We'll see you.
All right.
Mr. Ramirez, could you give me one moment? I have someone that just walked in the courtroom.
Of course.
Thank you. Okay, Mr. Ramirez.
Good morning, Your Honor.
Good morning. You doing okay?
I am doing well. How are you?
Good, good. Ready for the weekend.
Yeah, it's coming up.
Yes, it is. I like to call Friday. Even
Friday.
if I don't have anything to do.
You're like, I'll just do all the defaults that day so I can move on through them faster, you know? Yeah. You're like, get all these defaults out of my docket. I accomplished something this week, and you go home, have a good weekend. Yeah.
And then your client has a good weekend. You have a good weekend.
That's right.
All right. So are you and your client ready to proceed?
Yes, Your Honor.
All right.
I'm ready.
Okay. We're on the record in cause number DF 221714774. Counsel, would you please announce for the record?
Yes, Attorney Raul Ramirez for petitioner Elizabeth Perez-Faz.
Okay. Ms. Perez-Faz, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do, yes.
Thank you. You may put your hand down, and Mr. Ramirez, you may proceed.
Yes, Your Honor, before I proceed with my client's testimony, I ask the court to take judicial notice of the original petition and suit affecting parent-child relationship, which was filed with this court on September 28th of 2022.
Okay.
I
The court,
ask-
go ahead. I'm sorry.
No, go ahead, Your Honor. I'll go one by one.
Oh, I was going to say the court is going to take judicial notice of all of the contents in the entire file.
Okay, thank you, Your Honor. Specifically, I would ask the court to also take judicial notice of the affidavit of return of service, which states that the respondent was served on Thursday, December 15th of 2022, and that return of service has been on file since December 19th of 2022.
Got it. The court takes notice.
And I will call my client, Elizabeth Perez-Faz, for testimony.
Okay. You may
Uh,
proceed.
Okay, Ms. Perez, could you please state your name for the court?
Full name Elizabeth Perez-Faz.
And Ms. Pettis, both you and your son have been a domiciliary of Texas for the preceding 6-month period before you filed the original petition in suit affecting parent-child relationship, correct?
Yes, that is correct.
And both you and your son have been residents of Dallas County for the preceding 90-day period before the filing of the petition.
Yes, that is correct.
And what is the name of your son?
Adian Israel Gomez,
And when was his birthday?
February 15th, 2012.
Okay. And the respondent is Mr. Israel Scott Gomez, right?
That is correct.
And he's the biological father of Adian.
That is correct.
And you have submitted a proposed order in suit affecting parent-child relationship to this court, is that right?
Yes, that's correct.
And then that order, you're asking the court to appoint you sole managing conservator of the child and appoint Mr. Gomez possessory conservator of the child, is that right?
Yes, that is correct.
And you believe that's in the best interest of the child?
Yes.
Okay, and you have also put a possession schedule where the possession of the child will be by agreement only, is that correct?
That is correct.
And this, you believe this is in the best interest of the child?
Yes.
And you're basing this request on the fact that Mr. Gomez has been previously convicted of possession of a controlled substance with intent to distribute. And the times you have offered him to see the child, he exercises very sporadic possession, is that right?
That is correct. Yes.
And so that's why you believe it's in the best interest of your son that the possession will be by agreement only.
That is correct. Yes.
And you're also asking the court to order him to pay child support in the amount of $674.17.
Yes, that's correct.
And you arrived at this amount based on what you believe are $4,000 in gross monthly resources, right?
That is correct. Yes.
And you arrived at this amount based on your conversations and interactions and him disclosing to you that he has made these amounts in the past.
Yes, that's correct.
Okay. And so based on 4,000 monthly resources, you believe that $674.17 is the correct amount based on the child support guidelines, according to the family code.
Yes,
And you believe that's in the best interest of the child.
I do. Yes.
Okay. And now you also made a pleading for the court to award retroactive child support based on the fact that the respondent has not paid child support. Is that right?
That is correct. Yes.
And you're asking for the maximum of the statutory limit of 4 years based on $674.17 per month for a total of $32,360.16. Is that right?
Yes, that's correct.
And you believe that this retroactive child support is in the best interest of the child?
Yes, I do.
Okay. And you currently have been obtained new employment, correct?
Yes, that's correct.
Okay. And your employer has a window for offers health insurance, is that right?
Yes, that's correct.
And when you qualify, you will explore enrolling your son in that health insurance policy as well.
Yes.
Okay. And you have submitted an order in suit affecting child relationship which bears your signature to the court.
Yes.
And you're asking the court to sign that proposed order in suit affecting parent-child relationship.
Yes.
Your Honor, I'll pass the witness.
Thank you, Mr. Ramirez. I have a couple of questions for Ms. Perez. Let's see. I'm missing testimony, or maybe you can point me to it. I see that she talked about asking the court to appoint a sole managing conservator, and that being in the best interest of the child, but I do not see any testimony as to why she was making that request.
Yes, I believe she testified that the respondent has been previously convicted of possession of a controlled substance with intent to distribute, which is a felony. And so based on this conviction, she does not believe it's in the best interest of the child considering the drug history of the respondent.
Okay, that's what I'm missing then. So could you have your client speak more about the drug history as it relates to the child specifically? Because that within itself, the conviction of a felony wouldn't necessarily bar him from being a joint managing conservator.
Okay. Miss Perez, are you concerned that based on the respondent's history and conviction that he may use or have drugs in his possession?
Yes, I am concerned.
And does this based on that concern, are you afraid that perhaps he may be either using or dealing if he had possession of your son?
Yes.
Do you think that may put your son in danger?
Yes, I do.
And is that reasoning why you're asking the court to grant you the sole managing conservator?
Yes, that is.
Your Honor, I think that should suffice on the fear factor.
It does. Only, oh, and it was one other thing on the retroactive child support. The
Mhm.
court is not going to award that right now because in terms of the numbers, we would actually need the Attorney General present to give the exact calculation of that. And the order doesn't have enough language in it
Okay,
that would be specifically related to it. But that doesn't mean the court won't entertain it, on a subsequent motion. We would
Okay.
just need those numbers from the Attorney General.
okay.
And if you'll give me an income withholding order, that would be great.
Yes, Your Honor, I don't believe my client knows where the respondent is employed. He doesn't communicate that much to her. So if, we'll explore that once we actually have that information, if she's able to obtain it.
Got it. Okay. Is there anything further from your client?
No, Your Honor.
No, Your
Okay.
Honor.
The court
So-
after hearing, go ahead, Mr. Ramirez.
Yes, so Your Honor, so I guess the language about the retroactive should only be a line down the decree. I'm assuming the court is just going to strike that line from the order.
Yes, I did.
Okay, perfect. Okay, thank you, Your Honor.
You're welcome. The court, after hearing the testimony, the court will grant the request as ordered, just with the slight modification of the retroactive child support being crossed out. And when the time is appropriate for the income withholding order, the court will sign off on the income withholding order. The court also finds that the respondent was served on December 15, 2022. And that notice has been on court, their return rather has been on file with the court since December the 19th of 2022. The respondent failed to file an answer or a waiver, so he is by wholly made in default. And the order has been signed and you and your client will receive a copy of it today.
Thank you, Your Honor. May we be
Thank you, Your
excused?
Honor.
You're welcome. Thank you. Yes, you may be excused. Okay, good morning, Mr. Sullivan. See who else we have. Is it Frias?
Good morning, Your Honor.
Morning, good morning. And I see a James. James, what's your last name? Oh, hold on. You should have gotten a prompt that's asking you to unmute.
Smith,
Okay, what's your last name?
Smith,
Smith. Thank you, Mr. Smith. How are you?
wonderful.
Good. Let's see. Okay. Mr. Sullivan, your case, is it the James Smith and Christina Medina?
No, it's a Venegas case. Is that on your docket or am I in the wrong place?
You might be in the wrong place. You might need to be in Judge Lee's.
Let me fix that then. I'll get over there. Thank you, Judge.
You're welcome, no problem. Mr. Smith,
Yes, ma'am.
okay, you are ready to proceed?
Yes, ma'am.
1 second. Do you have the questions that you need to answer, or did you need me to ask those questions to you and you answer?
I would need you to ask those questions and answer.
Okay. 1 second. No. 11597. No children. I'm getting
No,
that
ma'am.
page right out so I can ask these questions of you. And I see that you did file the certificate of last known address and non-military status. Thank you.
Yes, ma'am.
Okay. And I believe I have your order too. Did you revise that order, Mr. Smith?
I did.
Okay. Because I'm not seeing the You have it in email that you can send to me?
I got an e-file email back saying it was accepted of the revision.
Okay,
And it was just, I had to check block 6 or something.
okay. There are a couple of blocks. Okay, I see block 6 checked. Okay, I think I'm looking at the right one.
Okay.
Okay. Okay, are you ready to proceed? Mr. Smith?
I'm ready when you are.
Okay, you ready?
I'm ready. Friday.
Friday, that's right. Okay, we are on the record in cause number DF 221597. Mr. Smith, would you please identify yourself for the record?
James Austin Smith.
Okay. And Mr. Smith, you are representing yourself in this case, is that correct?
Yes.
You're the petitioner in this case?
Yes.
Have you been a resident and a domiciliary, I always get tripped up on that word, domiciliary of Dallas County for 6 months preceding the filing of this divorce case?
Yes.
You and the respondent, which day were you all married on?
I don't remember.
Okay.
We were married in Las Vegas, September 21st, 2019, I believe.
Okay, and since that time, the two of you have separated and stopped living together, is that correct?
That's correct. We haven't been in contact or together in over a year.
All right. The marriage has become insupportable because of discord or conflict of personalities between the two of you, and that has destroyed the legitimate ends of the marriage relationship. Is that correct?
Absolutely.
Is there any chance of reconciliation?
Absolutely not.
Okay. Were there any children born or adopted of this marriage?
No.
All right. Do you, to your knowledge, is your wife pregnant at this time?
Absolutely not.
Okay. Any property that you all have, was there ever any accumulation of community property?
No, ma'am.
Okay, so you're just asking that your personal assets are yours and her personal assets are hers. Is that correct?
Yes.
Okay. Let's see. Do you know if your spouse is asking for a name change?
I have no idea.
Okay. All right. Are you asking the court to grant your divorce today?
Yes.
Okay. Oh, it was something else I needed to ask you. Christina Medina, she was served with a copy of this petition. Is that correct?
Absolutely. You should have record of that.
She was served on October 8th of 2022. Is that right?
Correct.
And the return of service has been on file with the court since October the 31st of 2022.
Correct.
Okay. Does that conclude your testimony?
Yes, ma'am.
Okay. Mr. Smith, I grant your divorce today. And as stated in your decree, Ms. Medina, the respondent in this case, she was served on October the 28th of 2022. The return of service has been on file since October 31st of 2022. She did not file an answer, nor is there a waiver on file. So she's made wholly made in default. And your decree will be sent to you here shortly. There are some blocks that I'm going to fill in and just put NA that is not applicable according to the testimony you gave here today. Okay?
Yes, ma'am. And then do I file that with the clerk?
No, you already did it. I have it. So I'll be sending it to you. Well, I won't do it. My coordinator will be doing it.
Friday.
Friday. That's right. Have a good weekend.
Thank you. Bye-bye.
Bye-bye. Okay, Mr. Alcorn.
Yes, ma'am. My first time in front of you.
How are you?
Oh, I'm doing fine. Oh, I don't think it's my first time to see a judge, but at least my first time in front of you.
Yes, this is our first time meeting. Nice to meet you.
Good to meet you too. It's good to hear a cheery voice on Friday.
I know, right? It's Friday. Okay.
It is.
I see your client is present.
Yes, ma'am.
Are you all ready to proceed?
Yes, ma'am.
Okay, just pull your case up here.
I'll, Vincent puts his in front, I put mine behind, it. Yeah.
Oh, that's funny.
Yeah.
5, 6. Okay, you ready? All right, we are on the record in cause number DF 2215666. Counsel, would you please announce for the record?
Jerry Alcorn, attorney for Dat T and Win.
Okay, Mr. Nguyen, would you please raise your right hand? Do you swear or affirm the testimony you'll give will be the truth, the whole truth?
Yes.
Okay, you may put your hand down. And Mr. Alcorn, you may proceed. Mr. Nguyen, could you come up to the microphone a little closer? My court reporter has to write down everything that you're going to say. Okay.
Mr. Nguyen, isn't it true that you and your wife lived in Dallas County for 6 months prior to filing your petition for divorce?
Yes,
And that there are no children in the marriage and none expected?
yes,
And this marriage become insupportable because the last time you saw your wife was on June the 5th, 2022.
yes,
And that you've contacted her, all the relatives you know, all the friends she know, and they were not able to tell you where she's located.
yes,
And you also did an internet database search and a find people search, but the only thing you have is her driver's license number. And you were not able to locate her using the driver's license number.
yes,
And she was served by posting, and that return of service was filed on February the 8th, 2023. Is that correct?
yes,
And during the marriage, there's been virtually no assets or liabilities accumulated.
yes,
And you're asking the court for a divorce today.
yes,
Oh. Mr. Alcorn, does that conclude your client's testimony?
Yes, ma'am.
Oh, okay. I was waiting on you to say this.
Oh, pass the witness. Okay. If you want me to say, how do you pass the witness or conclude it, I'll do
No,
it.
it's okay. I thought the signal dropped or something for a minute.
Yeah.
There.
Well,
Okay.
I don't, there was a judge about 25 years ago in Dallas County, and he schooled me 6 questions for, no assets, no kids, 8 questions for, children, and 10 for name change. And if you ask any more, he would,
Well, no, whatever you think is appropriate to prove up your case,
whatever you think's appropriate, I'm happy to do. Every judge has their little things. And but I always say, is it true there's no children in the marriage? And if they give a yes, I say, I'm not gonna, whoa, I guess you're pregnant. You said your wife wasn't. I've done that before too.
Oh, that's hilarious.
I know.
Well, the court, after hearing the testimony, the court grants the divorce. The court finds that the respondent was served in this case by posting on February 8th of 2023. That notice was, it was January 25th, 2023. That notice was posted here at the George Allen Court Building. It has been on file with the court since February 8th of 2023. The respondent did not file an answer nor a waiver, so she is made wholly in default. The decree has been signed, and thank you for the statement of evidence as well. It's been signed too.
All right. Thank you very much.
You're welcome. Have a good day or a good weekend.
You have a good weekend too.
Thank you.
Bye.
Bye-bye.
Did y'all get it today? Okay.
Good morning.
Good morning.
Morning.
Good morning. I have someone that just walked into the courtroom. The courtroom is open as well. And we're also live streaming on YouTube in accordance with the Texas Open Courts Act. So I will, as soon as I perform this wedding, I will be right back, okay?
Okay.
All right.
Thank you for your patience. Okay, I'm back. What? He took my pen. Yeah. Think this one doesn't work that good. Can you toss me one of those black ones right there? Thank you. Okay. Last name for me, is it Awoyemi?
Oh, yeah, yes. Yes, Your Honor.
Good
Yes,
to
ma'am.
see you virtually. Normally I
Good
see you
mo-
in person.
Yes. Good morning, Your Honor.
Good morning. Are you ready to proceed with your case?
Yes, ma'am.
Okay. Do you have your testimony that you're going to give, or you want me to ask you the questions?
You can ask me the question.
Okay, I will do that. Okay. Are you ready?
I'm ready.
Okay, we are on the record in cause number DF22142267. Mr. Awoyemi, would you identify yourself for the record?
Yes. Yes, ma'am. Your Honor.
State your name.
Awoyemi Johnson allowed.
Okay. And would you please raise your right hand? Do you swear or affirm the testimony that you'll give will be the truth?
Yes, ma'am.
Okay, you may proceed. Let's see, you are the petitioner in this case, is that correct?
Yes, Your Honor.
Representing yourself.
Yes, Your Honor.
Okay, please state your wife's name.
Oluwakemi Musmola Awoyemi.
She was served to be here. Well, she was served with a copy of this petition, is that correct?
Yes, ma'am.
You had to do it by posting.
Yes, ma'am.
That posting was performed here at the George Allen Court Building. Is that correct?
Yes, ma'am.
And the return of that posting has been on file with the court since February 23rd of 2023. Is that correct?
Yes, ma'am.
Okay. Have you been a resident and domiciled in Dallas County for 6 months preceding the filing of this suit?
Yes, ma'am.
Has your marriage become insupportable because of discord or conflict of personalities between you and your spouse that has destroyed the legitimate ends of the marriage relationship?
Yes, Your Honor.
Is there any expectation of reconciliation?
No, ma'am.
Okay. You and your spouse were married on or about May 10th of 2017. Is that correct?
Yes, Your Honor.
Were there any children born or adopted of this marriage?
None, Your Honor.
To your knowledge, is your spouse currently pregnant?
No.
Okay. Did either of you, did you all accumulate community property?
No, Your Honor.
All right. You are asking the court to award your personal assets and to award your spouse her personal assets. Is that correct?
Yes, Your Honor.
To your knowledge, is your spouse requesting a name change?
I cannot say, Your Honor.
Okay. Are you asking the court to go ahead and grant your divorce today?
Yes, Your Honor.
All right. The court takes judicial notice of all of the contents of the court's record. The court will grant your divorce today and you will receive a copy of your decree today.
Thank you, Your Honor.
You're welcome. Do you have any questions? We're off the record. Do you have any questions for me?
No question, Your Honor.
Okay. Well, you have a good weekend.
Thank you, Your Honor.
You're welcome.
Thank you. God bless.
Thank you. You too.
Can I exit now?
Yes.
Thank you, Your Honor.
You're welcome.
Yeah.
Okay. Mr. Brooks, how are you?
I'm fine. Thank you, Your Honor. How about you?
Your Honor, I'm here on behalf of Mr. Brooks.
Oh, okay. I didn't even see you up there. How you doing?
Doing pretty good. How you doing, Your Honor?
Good, good. Good to see you. All right. So let me pull your case up. Okay. How do you pronounce your last? Is it Nicole?
Nicole.
Nicole,
Your Honor.
Nicole. Mr.
Yep.
Nicole, are you ready to proceed?
Yes, ma'am.
Okay. You ready? All right. We are on the record in cause number DF2218157. Counsel, would you please announce for the record?
Yes, Your Honor. I'm Julian Nicole at the Nicole Law Firm, representing the petitioner Beretta Valentine Brooks.
Okay. Mr. Brooks, would you please raise your right hand? Do you swear that the testimony you will give will be the truth?
Yes, ma'am. I mean,
Okay.
yes, Your Honor.
Okay, Mr. Nicole, you may continue. You can put your hand down, Mr. Brooks.
Please state your name for the court.
Beretta Valentine Brooks Sr.
Okay. And at this time, Your Honor, I just ask that you take judicial notice of the filings and the affidavit and service citation that's on file in this case.
Yes, Your Honor. Yes.
The court takes judicial notice. Mr. Nicole, 1 second, off the record real quick. Mr. Nicole, I'm missing, I am missing the military affidavit as well as the last known address.
It should have been filed. I think we filed that.
The only thing I see on the court's file is the final decree of divorce. Well, I mean, of course, I see the return of service and everything like that, but I don't actually see the military affidavit and last known address.
Your Honor, if you would, will you give me 2 seconds real quick?
Sure, no problem.
Thank you. 1 moment.
Mr. Sullivan, you're back.
Yes, Judge, I think the confusion is that you may have the case listed under Zavala.
Oh, I do.
Yeah, because he has 2 last names, and I gave you his first last name, and Of course, it's under his last name.
Oh, okay, okay. So you and your client are here?
So I'm the publication attorney, but I believe the petitioner is here. The petitioner is showing up as Carlos Frias, but in fact, she's not Carlos Frias at all. She's, let me check.
Abigail.
What?
Abigail Padilla.
Abigail?
Yeah, Padilla. And I may need to interpret for her if the court will allow that.
Okay, spell Padilla for me.
Padilla.
Okay, got it. I hope I spelled your name right. Abigal?
Gail.
Gail. Got it. Okay. All right, give me 1 second. Mr. Nicole,
Yeah, yes, ma'am. So they were all filed and attachments to the default judgment. Do you want me to file them separately?
yes. Yes, I don't even see it attached to the order that I'm looking at.
Well, so the motion for default judgment, I believe they were attached to that.
Oh, okay, hold on.
And I can have them file marked and I can have them filed right now individually, but it's going to take some time for it to kick into the system.
No, it's on file. It's on file. You don't have to refile them. I see it attached to the motion.
Okay.
Okay, thank you. Yes, we're back on the record. Mr. Nicole, I was in the middle of saying that the court takes judicial notice of all of the contents of the court's file.
May I proceed, Your Honor?
Yes.
Okay. Mr. Brooks, you were married. Who was the respondent in this case? Who was your wife?
Nicole Mitra Brooks.
And you were married on or around September 9th, 1997, correct?
Correct.
And you guys have been separated for more than 10 years, correct?
Correct.
And there's no reasonable expectation of reconciliation at this point, correct?
Correct.
And she was served, correct?
Correct.
She was and she never filed any answer, correct?
Correct.
Okay. And she was personally served, correct?
Correct.
Okay. Now, you're asking for a divorce due to insupportability, or correct?
Correct.
And at this juncture, it's been indicated that she requests a name change, correct?
Correct.
And that name change is Nicole Metra Brooks, changing that name to Nicole Metra Felder, correct?
Correct.
There are no children that are under 18 that are a part of the marriage, correct?
Correct.
And there's no reasonable expectation that there will be another child.
Correct.
And currently the community property listed, you're requesting that all property, checking accounts, 401ks and everything from 2001 that is vested in your name solely be your sole and separate property, correct?
Correct.
And every retirement bank account and property in her name be her sole and separate property, correct?
Correct.
There is currently no real estate or any kind of community property that has both your names on it, correct?
Correct.
And in fact, you guys have not been living or talking to each other for more than 10 years.
Correct.
Okay. There's been no abuse or allegations of violence or family violence or anything else, correct?
Correct.
Now, you've lived in Dallas for 6 months preceding this suit for divorce, correct?
Correct.
So jurisdiction is good. You're asking for all debts that are solely within your name back to 2001 be your debts, if any exist, correct?
Correct.
Including your car that you're currently driving and everything else, correct?
Correct.
And you're asking that all her debts accrued solely in her name from 2001 be held by her, correct?
Correct.
And there's currently no community debt or anything else, correct?
Correct.
You attempted to reach out to her and get this without having to go through a default judgment, correct?
Correct.
So you are requesting attorney's fees, correct?
Correct.
In the amount of 2,500. In
Correct.
the amount of $2,500, correct?
Correct.
Okay. And in regards to any kind of policy of life insurance as well, any life insurance that you have or you've had that's in your name, you're requesting that be completely yours, correct?
Correct.
And you're asking the same for her.
Correct.
Okay. With that, Your Honor, I pass the witness.
Okay. Is there anything further for the record?
Just to say, essentially, Your Honor, just I'll testify just very briefly. Just for attorney's fees, if that's necessary. There's nobody to counter it, but I would just testify as an officer of the court that $2,500 is necessary and reasonable to this for filing the default judgment, doing the military affidavit. I'm trying to serve her for the cost of court as well. We attempted to get this done, but we were able to find her, but she never responded. To prove this up in the court and everything else, and trying to get her with her name change, we're requesting just essentially for the novelty and the county. I charge $3.50 an hour, and this is necessary and reasonable in this county jurisdiction pursuant to the Arthur Anderson factors. And with that, Your Honor, we rest.
Okay. The court, after hearing the testimony, the court finds that the respondent was served on January 5th of 2023 with the petition. The return has been on file since January 6th of 2023. She did not file an answer, nor did she file a waiver, so she is wholly made in default. The request for attorney's fees are denied. And I actually struck that from the default order that's here. And I have signed the order, Mr. Nako, and you will have it to you here shortly.
Thank you so much, Your Honor.
You're welcome. Have a good day. Have a good weekend.
You too, Your Honor.
Thank you.
All right. May we be excused?
Yes.
Thanks.
Okay, Mr. Sullivan, are you ready to proceed?
I am, Your Honor.
Okay, and you are welcome to translate for your client.
Thank you, Judge.
You're welcome. You ready? Okay, we're on the record in cause number DF 107449. Counsel, would you identify yourself for the record?
I'm Dan Sullivan. I am the publication attorney in this case, appointed to, I'm sorry, one moment, appointed to represent the respondent who was served by publication, which is Mr. Aurelio Zavala Venegas. Pardon me, Venegas Zavala.
Okay, so Ms. Padilla is the petitioner in representing herself, is that correct?
That's correct, Your Honor.
All right, all right. Ms. Padilla, would you please raise your right hand?
Señora Padilla, favor de levantar la mano derecha.
All right. Do you swear or affirm that the testimony you give will be the truth?
¿Jura o afirma que el testimonio que dará será la verdad?
Sí.
Yes.
Okay. All right. You may put your hand down.
Se puede bajar la mano.
Mr. Sullivan, would you please raise your right hand? Do you swear to correctly translate from English to Spanish and from Spanish to English?
I do, Your Honor.
Thank you. Okay. Give me 1 second. Okay, this is a suit affecting the parent-child relationship.
No, it's just a name change, Judge.
Oh, okay, I see it. All right. Okay, Ms. Padilla, you are the petitioner in this case, is that correct?
Señora Padilla, usted es quejante en este caso, ¿correcto?
Correcto.
Okay.
Yes.
You are the mother of the child, is it Gael Venegas?
Usted es la madre del niño Gael Venegas, ¿correcto?
Sí.
Yes.
Okay. What is the father's name?
¿Cómo se llama el padre?
Aurelio Venegas Zavala.
Aurelio Venegas Zavala.
Mr. Zavala, was he served with a copy of this petition for the child's name change?
El señor Zavala recibió el citatorio con una copia de esta demanda para el cambio de nombre.
Yo hice todo por encontrarlo, de hecho pagué en la corte también para que fuera publicado en el periódico de la corte, pero no lo encontramos. Por eso el juez me otorgó.
Oh, espere, porque no puedo recordar todo eso.
Okay.
I did everything to try and locate him, and I also paid for the court to publish the notice on him, but I wasn't ever able to find him.
Okay. And that notice was published in the Daily Commercial newspaper on October the 6th of 2021. Is that correct?
Y ese citatorio fue publicado en el Daily Commercial Record en noviembre de 2021, ¿correcto?
Sí.
Yes.
And it has been on file with the court since November 11th of 2021. Is that correct?
Y ha estado en el archivo de la corte desde el 11 de noviembre de 2021, ¿correcto?
Sí.
Yes.
Okay. What is the reason that you are looking to change the child's name?
¿Para qué razón busca cambiar el nombre del niño?
Porque mi hijo en la actualidad tiene 5 años y bueno, ya 6 años y él no lo conoce. La que se lleva responsabilidades del niño soy yo.
Because he's 6 years old now, and he doesn't know his father, and the one who's responsible for him is me.
Okay. Do you believe that this name change of your son will be in the best interest of your son?
¿Cree usted que este cambio de nombre para su hijo será en los mejores intereses de su hijo?
Sí, por supuesto.
Yes, of course.
Okay. And the child's name will change from Gael Venegas, that's Gael spelled Gael, to Gael Padilla. Is that correct?
Y el nombre del niño se cambiará de Gael Venegas, Gael deletreada Gael a Gael Padilla, ¿correcto?
Correcto.
That's right.
Okay. All right, that's all the questions that I have for her. Mr. Sullivan, are you ready for your portion?
I am, Your Honor. So this is Mr. Venegas. Venegas would be his usual last name in Spanish because he has 2 last names, of course, Venegas and Zavala, but Venegas being the first, his father's last name is primary. I've looked for him under both last names. The truth of the matter is there's not much to go on. Ms. Padilla hasn't seen him in years, and she believes he's probably back in Mexico. She has no relatives for him in this country that I could try to contact. So what I'm limited to in this case is that I sent a letter to his last known address with no response, and I've looked for him on internet sites. with nothing that could realistically be him. Again, looking for people on the internet, sometimes you find them, sometimes you don't, but people who are maybe don't have a good immigration status, it's usually impossible to find on the internet, and that's what I found here. So I don't think there's anything more I could do that would have any reasonable prospects of finding him. I think he's properly before the court.
Okay. Thank you, Mr. Sullivan. The court, after hearing testimony, grants the child's name change. As stated in the testimony, Mr. Pronounce his last name for me.
Venegas Zavala.
Venegas Zavala. The court finds that he was served by publication and he is proper before the court. The name change order has been signed. It will be sent out to you all today.
Thank you very much.
You're welcome. You're welcome. We're off the record. Do we have your email address?
You do, Your Honor. Yeah.
Okay. Just making sure. Thank you.
Thank you, Judge.
You're welcome.
Take care.
You too. Thank you. Okay. Hi there. How are you?
Hi, Judge. Good. How are you?
Good, good. I see. I don't have this. Oh, this one must have just been added. It's for an adoption, right?
Yes, Your Honor.
Okay. Who else are we expecting?
I think I just asked my my people. They're in the next previous room, I guess. They showed me a picture of like the first screen, like when you first log on.
Is this Cameron?
Yes, Your Honor.
Okay.
There we go. That should be them. Okay, so he's muted. There's camera. There we go. There's camera.
Okay. Okay. I hate that everybody is not here. I have a beanie baby. Hey, Mr. Fratter, maybe at some point you could come to the court and get the beanie
Absolutely.
baby. Okay.
And Judge, just they've been patiently waiting, because of COVID and everything, for us to get all of this sorted. So I told them that this was the quickest way, and they had mentioned, and I had mentioned that this can be done, in person and everything too. But they just they're ready to get this done, and so we're happy to be here for sure.
Thank you. Thank you. Okay, so let me pull this up really quick.
Yeah, and Judge, I had just walked the order in yesterday, realizing that none of this can get e-filed. So I brought it in yesterday and dropped it at the clerk, and she said she was adding it to the queue or something like that.
And she did. She did.
Okay, perfect.
All right. Are you ready to proceed?
I am.
We are on the record in cause number DF2116830. Counsel, would you please announce for the record?
Yes, Your Honor. My name's Mark J. Fratter. I'm here on behalf of Kimberly Christine Huertas and Cameron Alexander Kirby. They are the petitioners in this matter, specifically the termination of the parental rights and the adoption by Cameron Kirby of Hunter.
Okay. All right.
And first, Your Honor, I'll just kind of get some of the administrative things taken care of. So what should be, I guess, accessible to the court to see is that on the 29th of November, at 3:54 p.m., Hayden Preston New was properly served with the original petition to terminate and for the adoption of the child. Now, prior to that, and after me speaking with Mr. New, as you'll see as Exhibit A, he executed a voluntary relinquishment of his rights. Therefore, as I put in the order, and I guess if the court, feels this needs to be changed, I had expressed that, for purposes of the case, I believe that would constitute a general appearance because he's actually entered himself into the case by executing that affidavit. Now, just so the court is aware, I did inform Mr. New about today's hearing if he wanted to appear. I sent it to the last known address I had for him, and I don't believe he wanted to attend, and especially considering what was reported to our adoption evaluator, Miss Bradshaw Schmidt, that he basically was okay. Was happy this was happening, and just really didn't want to have any part of it, moving forward. So I'll just ask the court, I guess, to take judicial notice of the citation and the affidavit of the service of the citation on Mr. New, as well as the original petition to terminate and for adoption of child in all the accompanying exhibits, letters A, B, C, D, E, and F.
Those are exhibits that you're going to tender to the court today?
Yeah, that was part of the petition.
Okay.
And so just to take judicial notice of the petition, as well as the exhibits, and then especially on behalf of Ms. Bradshaw Schmidt, who I've spoken to in the last few days. She's completed her evaluation, which has also been tendered to the court. I know there were a couple collateral matters that she was finally able to wrap up, and so those I think came in later. But everything that she needed to do is completed and is also in front of the court. So again, for the purpose of that, and I believe she just generically refers to it as just adoption evaluation. And I think one is 13 pages, and then I think there are a couple that are just a couple pages.
Okay.
So I'll just submit that to the court to take judicial notice of the contents of the file.
Yes, you can take judicial notice of all of the contents of the court's file.
All right, thank you, Your Honor. And with that, I'll call Ms. Huertas first.
Okay, could
All right.
both of you raise your right hand? Do you swear or affirm to tell the truth? The testimony you give will be the truth?
Yes.
Yes.
Thank you. You may put your hands down. Mr. Fratter, you may proceed.
All right, thank you. All right, go ahead and state your name, Kim.
Kimberly Christine Huertas.
Okay, and actually, as of today, and actually as of several months ago, you are now married also to Cameron Kirby, correct?
Yes.
Okay, and at the time of the filing of this petition, you were engaged but not yet married, correct?
Yes, sir.
Okay. And so we've been married now for several months. And
It's a year. We got married in September of 2021.
2021, yeah.
Yeah.
Okay.
21, yeah.
Okay. So who is Hunter Preston New?
He is my son.
Okay. And how old is he?
He's 8.
All right. What's his date of birth?
January 25th, 2015.
Okay. And he is the child that's the subject of the termination and the adoption, correct?
Yes, sir.
Okay. And let's go ahead and get through the termination first. Mr. New executed a affidavit for voluntary relinquishment of his parental rights, correct?
Yes.
Okay. And in addition to that, we also identified several other grounds. If for whatever reason that was not sufficient, that we would also would use as grounds for termination of Mr. New's rights, correct?
Yes.
For instance, he is, prior to the filing of this petition, he had not provided any sort of support for Hunter for well over a year, correct?
Correct.
Okay. I believe he had had no contact with Hunter for well over a year, correct?
He hasn't seen Hunter since January of 2016.
Okay. And it's safe to say that he's had really no real participation in Hunter's life from basically the get-go, correct?
Correct.
Okay. And I believe it's also safe to say that Cameron, on the other hand, has essentially been around from the beginning and has functioned in that capacity as father, and in fact, that's who he is to Hunter, correct?
Yes.
Okay. And you believe it is in the best interest of Hunter that the parental rights of Hayden be terminated, correct?
Yes.
Okay. Okay. And some of these, Kim, these are just sort of more just, I'll just call them sort of procedural questions. We submitted to the court and you signed off on a what's called the interstate placement, basically affidavit, and that is attached as Exhibit A to this petition. Do you recall? I know it was a long time ago, but do you recall doing that?
Yes.
Okay. All right. Now, you are asking the court, kind of step one is to approve the termination of the rights of Hayden. But you're also asking simultaneously that Cameron be allowed to adopt Hunter as well, correct?
Yes.
Okay. And Hunter, again, prior to both prior to and after the filing of this, has resided in your residence, both with you and Cameron, correct?
Yes.
Okay. All right. And again, just a procedural question. There is no property of consequences owned or possessed by Hunter at this time, correct?
No.
I believe we had asked Hayden at some point to complete what's called a medical history report. I have not received that. Have you ever received a medical history report from Hayden?
No, I have not.
Okay. And I don't believe there's probably any hope that will be submitted. So I don't believe at this point it's something that the court necessarily needs to order. Are there any medical concerns that you have for Hunter?
No. He has asthma, but I mean, I'm sure he'll outgrow it.
But I guess basically anything about Hunter and any medical issues he may have, though, you're well aware of all of those things, correct?
Yes. Yes.
Okay.
He's healthy. He's good.
Okay. And so I know, and I'll get into this here shortly with the adoption evaluation, but I know that there were necessary things that had to be submitted to Ms. Schmidt for purposes of his health, correct?
Correct.
Okay. And I may have already asked this, but in case I haven't, I know that there were many things that Christy asked you to submit, both you and Cameron. And I know it took a while sometimes to get those together, but you complied completely and fully with Christy's request for providing her with everything she wanted, right?
Yes.
Okay. I think the last few things were just waiting on some criminal history things to come back, some health things to come back. And I think that was the last few things we were waiting for, but those have since been submitted to the court. It's your understanding, correct?
Correct.
Okay. Okay. All right, so let's now okay. I'll go ahead and call Cameron, Your Honor.
Okay.
All right. All right. Go ahead and state your name, Cameron.
My name's Cameron Alexander Kirby.
Okay. And who are you as far as Hunter Preston New goes?
So I'm his father, or I guess technically stepfather at this point.
Okay. And you, along with Kim, your wife, you had filed back in October of 2021 jointly this petition to terminate and for the adoption of Hunter, correct?
Correct.
Okay. And the things that I asked Kim, and I go, and if you don't remember some, just tell me, we can go through them again, but I'm assuming that your answers are going to be the same or similar to what her answers were, as far as you know, those questions were asked specifically, you know, whether Hunter has resided with you, you know, 6 months prior to and even 6 months after the filing of this petition, correct?
Absolutely.
Okay. In fact, you and Kim have been together even before being engaged for quite some time. Then you were engaged. Then you've been married, and I believe almost most, if not all, of that time, Hunter has also not just been under her care, but your care, correct?
Yeah, for a little over 6 years.
Okay. And again, as far as Christy and her evaluation goes, you were asked to I know, do a lot in preparation for that. And you know, she generated a couple different reports here, but were you fully and totally compliant with all of her requests?
Absolutely.
Okay. Is there anything at this point that, you know, based on what you recall reporting to her during the duration of the last, you know, year and a half or so, that has changed in any way that we need to let the court know?
No, not that I recall.
Okay. And again, looks like there were multiple letters of support that were provided. I think earnings statements, driver's license, pictures, marriage license. There was photos of your home. Looks like someone did some sort of drawing of the interior of the home. I think maybe Kim did that.
Correct.
And so these were all, I'm assuming, were requested by Christy while she was doing this evaluation, correct?
That's correct.
Okay. And Cameron, do you also believe that's in the best interest of Hunter for the rights, the termination of the rights of Hayden, as well as the adoption by you? Do you think that's in the child's best interest?
Absolutely.
And I'll ask you this first, since you're already up, Cameron. Do you, or I guess, are we asking the court basically to order the termination the parental rights of Hunter, or I'm sorry, of Hayden, as well as grant the adoption, both of which are contained in one petition that was filed on 10/21 of 2000, or I'm sorry, 10/12/2021. We're asking the court to grant the order, both terminating the parental rights as well as granting the adoption. And those two things are both found in the order that was submitted to the court yesterday.
Yep, that's what we're asking for.
Okay. And there are findings in there as far as, and I'll give an example, that the court finds that the required adoption evaluation, including post-placement reports, have been performed and are on file herein. You're asking the court to adopt the findings that are also contained in that order as well, correct?
Yes.
Okay. I think the last thing is we're asking for the change of the name. I'm trying to, from Hunter Preston New, I believe, to now Hunter Christopher Kirby. Is that correct?
Correct.
Okay, and that's obviously to reflect that you are the father of the child, correct?
Yes, sir.
Okay. I believe. All right. And at this time, I'll call back Kim just quickly so we can have her answer the last few questions remaining.
Okay.
That's okay. All right. All right. So Kim, you're aware that the court was given an order yesterday, and we're asking the court to sign that order, correct?
Yes.
Okay. And contained in that order is both the determination of the rights of Hayden, as well as the adoption by Cameron Alexander Kirby of Hunter, correct?
Correct.
Okay. In that we are asking for the name change from Hunter Preston New to Hunter Christopher Kirby. Is that correct?
Correct.
Okay. In that, another thing that we were asking to be ordered is that the clerk of the court will basically transmit to the Vital Statistics Unit at Austin, Texas, a certified report of adoption in accordance with section 108.003 of the Texas Family Code. We are asking the court to order that, correct?
Correct.
Okay. And in addition to that, we're asking that all papers and records in this case, including the minutes of the court, be ordered sealed, correct?
Correct.
Okay. All right, and I think with that, Your Honor, at this time, I just ask that the court sign the order terminating the parental rights, granting adoption of the child, be signed, including the name change, and that's it.
Okay. The court finds the testimony, after hearing the testimony, the court finds that it will be in the best interest to terminate the parental relationship between the child and Hayden Preston New. So that relationship is terminated. The court also finds, after reading the adoption report by Christy Bradshaw Schmidt, that it would also be in the best interest of the child for the child to be adopted by Cameron Alexander Kirby. The child's name, I added it to the order. The name change wasn't specifically in the order, but I did add it. It is ordered that the child's name Former name of Hunter Preston New is now Hunter Christopher Kirby. I have signed the order and congratulations.
Thank you very much, Your Honor.
Judge, can you give me a minute to get Hunter in here so you can tell him what his new name is?
Absolutely. Congratulations on your marriage too. I
Oh, thank you.
21st. You're welcome. Off the record. Yes, I need Hunter to get his, if you all don't mind bringing him to court, he can pick out his own Beanie Baby.
Absolutely, Judge.
Okay.
You gonna validate parking?
I wish. That would be a cool idea, right?
She isn't gonna tell you.
Is Hunter shy? Oh, Hunter, you're super handsome. How are you?
Say good.
Good. Can I tell you something really sweet? You have a new name. How exciting is that? Hunter, your new name is Hunter Christopher Kirby.
Are you excited?
It's so nice to meet you.
You can't tell, he's a little bit shy.
I can tell. Well, thank you all for being here. Congratulations again. I was telling Mr. Kirby, whenever you all get an opportunity to bring Hunter down here, I would love to meet him in person and allow him to pick out his own Beanie Baby.
Wonderful.
That sounds awesome.
Okay. Well, you all you're very welcome.
Thank you very much, Your Honor.
You're welcome. Bye.